case of infringement of their rights. And therefore, under the law of Tanzania, the act I mentioned earlier, these procedures are provided under Part 5, but under the TRIPS agreement, the procedures are provided under Part 3. And therefore, to comply with this, our country now through its parliament enacted this act, the Copyright and Neighboring Rights Act, which now under Part 5 provides for those procedures in which a performer, in case of breach of his rights, he can obtain a redress. And the specific forum now for this performer to obtain a redress is the district court. When you pass through section 4 of this act, you will find that there is yes, it is under section 4 defines what court means. Under this section, a court means the district court. And therefore, if a performer's right has been infringed, then he can obtain a redress from the district court, from the hierarchy of courts in Tanzania. And therefore, apart from the breach of the rights and the forum in which a person can go and obtain a redress, which is the district court. Now, to support this, that the district court has original jurisdiction regarding infringement of intellectual property rights in Tanzania, there is a case of Juma Hamisi, in which the court infringement of intellectual property rights in Tanzania, copyright and performance rights being one of those intellectual property rights. So I was also assigned to pass through the legal challenges facing the protection of performers' rights in Tanzania. So the legal challenges facing performers' rights in Tanzania, of course, I found the three major challenges. One being that in Tanzania, there is no a comprehensive legal framework for the protection of performers' rights in digital environment. Because we know now, because of advancement of science and technology, now performers' rights or the works of performers can easily be transmitted from one person to another or distributed from one person to another. And therefore, absence of a law ensuring protection of the rights of performers in digital environment, of course, it is a challenge to performers. However, there is an act of the parliament called the Cyber Crimes Act, which under section 24 prohibits a person to use a computer system to violate intellectual property rights provided in any written law, the copyright and neighboring rights being one of those laws. And therefore, we can say this somehow brings in the protection of intellectual property rights, particularly performers' rights. But this act has challenges. One of the challenges that it does not define what digital environment means, but also it does not contemplate the doctrine of fair use, because it just says if a person infringes, violates, without taking into account that the rights which are provided in intellectual property regime, they have exceptions. And therefore, non-consideration of the definition of digital environment and non-consideration of the fair use as one of the exceptions, of course, brings a challenge with regard to performers' rights in Tanzania. But apart from that, you know, intellectual property is a new phenomena, a new field in law, and therefore it needs legal practitioners and the judicial officers who are skilled or acquainted with skills regarding infringement of intellectual property, performance rights being one of those intellectual properties. So absence of judicial officers and legal practitioners skilled in intellectual property, it is a challenge on performers' rights in Tanzania. But the other challenge, which might be the last from my list here, is that uh, enforcement of the rights of performers in case they are breached beyond the territory of Tanzania, it is a challenge indeed, because we say uh, uh, technology has no boundaries, and therefore a right of performers in Tanzania can be infringed by another person from another country, and therefore enforcing the rights in that country might be a problem, because we say intellectual property rights including performance rights, are protected territorially, only in the territory in which they are granted. And therefore, if within the territory they are protected, then they cannot be protected in another country unless the owner applied for protection in that another country. So as it has been pointed out by Odinga, that Tanzania is still not a member to the WIPO Performances and Phonogram Treaty of 1996, then the performers cannot benefit from the one of the principles in IP, which is the national treatment. They cannot benefit from this principle, and therefore it becomes a challenge to them in case of infringements which are done in other countries beyond the territory of Tanzania. Therefore, maybe just to sum up, that a breach happens if the exclusive rights of performers are exercised by other persons without their authorizations. And the forum which a performer can approach in Tanzania for redress is the district court. And from there, he can appeal to the High Court and lastly to the Court of Appeal. And the legal challenges, as I pointed out, of course, needs to be addressed. One is Tanzania to sign and ratify the WIPO performances and phonogram treat, but also ensuring that there are specialized courts and specialized judicial officers and legal practitioners to appear in court for determination of a dispute on infringement of intellectual property rights, particularly performance rights, but also ensuring that we have a comprehensive legislation which defines what digital environment mean, and also ensuring that some of the exceptions are provided in those laws so as to realize the balancing of interest in intellectual property law. Thank you very much.
Thank you very much, Juma. Thank you for that presentation. Still on the fora for redress of performers, the breach of performance rights, we would have Ms. Amanda Uzuokwa to take us through the Nigerian system. But before that, just reminding all attendees to continue sending in their questions. We have someone from the Kabusa Choir who is standing by to respond to your questions. So yes, our second discussant, Ms. Amanda Uzuagba, welcome, and please, we have 5 minutes to present.
Hi, Winnie. Thanks so much for the introduction. Hello, everyone. Thank you for giving me this platform and for having me here. So I'll try my best to stay within the 5 minutes and not talk a lot. Now, my colleagues that have given background on performance rights and how to enforce it and everything. One thing you have to understand is that copyright is kind of a bit universal. Our rights, or rather our laws, are a bit identical to others. There's not much difference. So their background or the background information they've given can cover for Nigeria to an extent. So performance rights is established, or rather is provided for between section 23 and 27 of the Copyright Act. And one thing we can agree on is the extent to which the rights provided by that, or rather one thing we can agree on is the extent of the rights given by the Copyright Act, and it's just down to broadcasting and adaptation, basically broadcasting, recording and adaptation of the performers is not like, well, performers are not really that well protected in Nigeria, that I would say. So when it comes to enforcing the rights, or rather the challenges you face for